Good morning. What I will be talking about this morning is documentation and how the chart is used in the process of litigation. I'm also going to cover with you the reasons why patients or plaintiffs go seek out plaintiff attorneys to file litigation, and some of the factors that contribute to errors. We're going to focus a little bit on miscommunication and on delay in treatment. And then finally, I will wrap up with talking a little bit about computer order entry and give you some case studies that emphasize the importance of having clear and legible orders. The most common reason that plaintiff attorneys are contacted by patients or their families when there's a bad medical outcome is they want to know what happened. They can't figure it out. They've asked for an explanation. Maybe they didn't understand the explanation. Maybe they didn't get an explanation. They're looking for answers. And they believe that by contacting a plaintiff attorney and having somebody look at their records, they will find out what happened. At that time, the resident was told by the nurse and by the mother of the patient who was at the bedside that her daughter did not tolerate opiates well, but she had received Toradol in the past and had gotten a good response from that. The resident's response to the nurse and to the family was, "I'm the doctor, I know what I'm doing." And she left the Demerol order as is. What was key in this case was that there was an assessment form that was supposed to be completed by the nurses. They were supposed to evaluate level of consciousness. And you can see that it was done at 12:40, but there is no subsequent documentation of level of consciousness. When the patient had her arrest, there was a blood level drawn, and they found toxic levels of Demerol in her blood, to the point that it caused this patient to have a respiratory arrest, to be put on a ventilator, and then life support was withdrawn 4 days later. For example, it may happen like this. The nurses who work in the labor and delivery area have concern about changes on the fetal monitoring. But they were, in this particular case that I'm referring to, which was a North Carolina case, they were reluctant to talk to the obstetrician because he had a response that was typically negative when nurses approached him about concerns about a patient. So they did not approach the physician, and there was a bad outcome with the infant, and there was a $1.2 million settlement. A study that was done by the Institute for Safe Medication Practices focused in on how frequently this is occurring and discovered that when about 2,000 healthcare providers were surveyed, that the problem was much more pervasive than they realized, with the majority of people saying that they had not clarified orders for medications, for example, because they were intimidated by the response that they were likely to receive from a particular provider. I'll give you an example. I've reviewed several cases of people who have fallen out of Hoyer lifts when nursing assistants were moving them. As they're swinging through the air, they get dropped onto the floor, usually resulting in a fractured hip or a subdural hematoma. Nursing assistants, in at least several of the cases, were afraid that they would get in trouble by saying what happened. So they did not report the incident. The nurse who was evaluating the patient detects that the patient's complaining of leg pain, the leg is externally rotated, it's shortened, it's causing all kinds of concerns about what happened here, but the medical record has no information about it. So in that instance, the plaintiff attorney could assert that there was a cover-up of the original injury. An interesting note that I once found in a nursing home record was an entry that said, "Please leave the 3 to 11 shift enough room for documenting the fall when they rewrite the nursing notes." That's considered tampering with records, and in that case the suit was resolved even before it got filed. This is an order for cisplatin, and this was a case involving a 9-month-old infant who was supposed to receive 20.4 milligrams. Got 204. When the order was transcribed, the decimal disappeared. When the order went down to the pharmacy, there was a warning on the cisplatin that recommended double-checking any dosage that would be in this level. 2 people checked the order but didn't pick this up and supplied it to the nursing unit. The child received the chemotherapy and died 2 days later, and when the autopsy was done, they found toxic levels of cisplatin in his blood.
It was important to us at our hospital to have our clinical staff educated regarding the impact of their documentation to future potential litigation. We asked Pat to come and address our staff on her experiences as a legal nurse consultant and basically give us some insight into how our documentation can protect the healthcare provider and the hospital in the future. We found the presentation very helpful. We had 2 sessions. We have counted 108 people in attendance, which is a remarkable feat for getting people to attend in services within the hospital. It is a subject that our staff are hungry for a better understanding of. I think it will affect how they go back to work. Specifically, I think it will raise their awareness about their role and responsibilities in keeping an accurate record of their interaction with patients, their families, and the other healthcare providers. And I think it will increase their awareness of following a chain of command. I think that was a very important message that got put across today. Pat was able to relate to the audience, questions were generated, and I think it was very successful.